Understanding lack of capacity. Making an advanced decision to refuse medical treatment. If you think your health will affect your ability to make decisions in the future, you can make an advanced decision to refuse medical treatment. This can detail treatment you don't want to have. Some health conditions may mean you can't make and communicate your own decisions. This is known as a lack of capacity. If you're concerned about having a lack of capacity in the future, you can state what medical treatments you would not want at that future time. The statement, verbal or written, is called an advanced decision to refuse treatment. You may have heard of a living will or an advance directive before. These were ways of explaining how you wish to be cared for in the future if you lost mental capacity. They might have included how you wanted or preferred to be cared for, such as always having a shower instead of a bath. However, an advanced decision only applies to where you want to refuse medical treatments. You can't use an advanced decision to ask for specific medical treatment or anything that is against the law, for example, requesting help to commit suicide. Say you want someone else to decide what treatment you should have. If you want to choose someone to make decisions about your treatment, you have to make what is called a lasting power of attorney. Your advance decision will only be valid, accepted legally and by healthcare professionals, if you are 18 or over and had capacity when you made it. Have set out exactly which treatments you don't want in future. If you don't want life-saving treatment, your decision must be signed and witnessed. Have explained the circumstances under which you would want to refuse this treatment. Have made the advance decision without any harassment by, or under the influence of, anyone else. Haven't said or done something that would contradict the advance decision since it was made. Advance decisions to refuse treatment are covered by the Mental Capacity Act 2005, which became part of law in April 2007. By law, a valid advance decision refusing life-saving treatment means you can't be treated. If a doctor did treat you, legal action might be taken against them. There's no set format for making an advance decision, but it is helpful to include the following: your full details, a clear statement of the treatment to be refused and the circumstances in which the decision applies, the date you wrote or reviewed the document, your signature or that of the person writing for you, if you are not able to write. Make sure your close relatives, friends, GP and medical staff know about what you have put in your verbal or written advance decision. You can also get help from your care coordinator or doctor. By law, if you want to make an advance decision refusing treatment to keep you alive, you have to make a written statement. If you can't write, ask someone else to do it for you. Sign the decision and put a date on it. If you can't sign it, ask someone to sign it while you are present. Get a witness who has mental capacity to sign the decision confirming that you have signed it, or ask someone else to sign it while they were present. Make sure the decision says that you are refusing the treatment you have mentioned even if your life is in danger. You could allow for new treatments in your advance decision even if you don't want ones that are presently available. A doctor might not follow an advance decision if you have done something to contradict the advance decision. For example, changing your faith to a religion that doesn't allow refusal of treatment. They think that new circumstances would have affected your decision. For example, a new treatment that could have a big effect on your health condition. The advance decision isn't clear about what should happen. Also, a doctor might not follow an advance decision because it refuses treatment for a mental health condition. Under Part 4 of the Mental Health Act, a doctor is allowed to treat you without your consent for a mental health condition. An advance decision to refuse other forms of treatment will still be valid. A doctor can also treat you if there is a doubt or a dispute about the validity of an advance decision, and the case has been referred to the courts. Want to review your situation? To arrange an appointment or to discuss any concerns that you may have in relation to making appropriate protection for you, your loved ones and your estate, please contact us. We look forward to hearing from you. Smith Equity and Trusts 020-7193-0946